The so-called Safety of Rwanda Now Act. It's a terrible, terrible piece of post-truth legislation. The legislation disapplies the Human Rights Act from these particular people. So they become less than human. I think it's populist and it's far right to demonise them as a distraction from unconscionable inequality, poverty in one of the richest countries on earth. Food banks next to investment banks, and nurses that we were clapping a short while ago now going to food banks, using the demonisation of minorities as a distraction from that. I call that far right, yeah.
Baroness Shami Chakrabarti, wasn't it? PoliticsJOE. Oh, was that a giggle at your name or the Baroness?
Shami.
Yeah.
Will do.
Fine, happy days. For those of you who may not be familiar with your work, how would you like to introduce yourself? As Shami.
I'm Shami Chakrabarti. I'm a human rights lawyer, campaigner and a Labour peer.
Your new book, I should say, Human Rights, The Case for the Defence, is particularly poignant in light of all kinds of recent political events. I think the two standout ones, which we'll probably cover over the course of the conversation, are the Rwanda bill and what's happening in Israel and Palestine as well. So let's start with Rwanda.
Yeah.
Broad question, does the Rwanda plan infringe on human rights?
Yes, it does. But you knew I was going to say that.
I did, yeah.
I think the so-called Safety of Rwanda Now Act is one of the most awful pieces of human rights violating legislation that even I have seen. And, you know, I'm full of this broken record because that's what I do. It's a terrible, terrible piece of post-truth legislation. So it doesn't just offend and violate the human rights of the most vulnerable people on the planet who are desperate asylum seekers in small boats. It also offends everything we believe about the rule of law. And by that I mean that it reverses a finding of fact by the highest court in this land, not what Mr. Sunak calls a foreign court, or what I would call an international court of human rights in Strasbourg. The Supreme Court, as you know, last autumn found that the Republic of Rwanda is not safe for asylum seekers and refugees. There was nothing political or rude or racist about that finding. It was just on an analysis of the evidence, and the evidence of UNHCR, the United Nations High Commissioner for Refugees, was particularly compelling to the court. Rwanda is not currently a safe place for asylum seekers and refugees, in particular because there's a risk that they will be sent on to other unsafe places, including the places they originally fled. And so Mr. Sunak's response to the Supreme Court, which I think even he called a foreign court as well at some point. I think this isn't stop the boats, this is stop the courts, okay?
Stop the law.
Stop the law. And so he then uses his parliamentary majority in the House of Commons to reverse a finding of fact and to legislate for Rwanda as safe, not just now, but for all time. In other words, to stop the courts doing their job in any civilised society, which is to analyse the facts about whether Rwanda is safe in general and whether Rwanda is safe for a particular desperate person. And so that's an extraordinary piece of human rights violating, rule of law violating, truth violating legislation from this sort of desperate failing prime minister who's now making even human rights and the law a kind of culture war issue. So we're not just having a go at trans people or woke environmental protesters. We're now going for the courts, the legal system, the Refugee Convention, which I do think is poignant because it was literally a direct response to the Holocaust of the last century. You know, when people tried to flee Hitler and couldn't always flee, when people were writing to the Home Office, Sylvia Pankhurst, the great lefty suffragette, was writing to the Home Office saying, please take more people who are trying to flee Hitler. And it's that kind of lesson that led to the Refugee Convention, which now Mr. Sunak wants to violate.
We'll go into some more detail on Rwanda in a moment, but I was struck by something you said initially, which is that this is kind of the latest and most egregious, possibly, piece of legislation in relation to human rights. So maybe you could give us a bit more of an overview and a build-up to that sort of legislative, perhaps, war or just authoritarian war on human rights, and I'm particularly interested perhaps in the context of sort of a new Labour government and the crackdown on civil liberties that we witnessed under Tony Blair, and how that's led us to the moment that we are in now.
So 20 odd years ago, well, it's a bit more than 20 years ago now, we saw the beginning of the war on terror.
Yeah.
And we had this kind of contradiction then, which was on the one hand, we had a Young Human Rights Act, which, to be fair, was Tony Blair's legislation, but it was passed with cross-party support. There were even, Dominic Grieve, who later became a Conservative Attorney General, made his maiden speech, for example, in Parliament in favour of the Human Rights Act in 1997-8. It was passed in 1998. It wasn't brought into force, the Human Rights Act, until 2000. And then, of course, a year later, 9/11 happened. So we had this sort of tension and contradiction, which was on the one hand, we had our modern British Bill of Rights, or the closest thing to a modern British Bill of Rights. It's not entrenched, it's just like any other piece of legislation, but at least it brought the European Convention of Human Rights into direct force in the UK. We had that positive thing on the one hand, but on the other hand, we were going down the road of demonising immigrants and asylum seekers in particular. We were going down the road of playing a lot of politics with law and order, ASBOs, CRASBOs, the criminalisation of naughty kids, stop and search without suspicion. We began on a road which to some extent has continued and accelerated.
Detention without charge.
Yeah, we did. Yeah, after 9/11, we, in an act of sort of solidarity with George Bush Jr., went in for indefinite detention, internment, without charge or trial. And that's me when I was working for an organisation called Liberty, the National Council for Civil Liberties, being in direct argument with some of the people who are now my colleagues on the Labour benches in the House of Lords. It's a funny old thing, life, isn't it?
Nice to see them again in the House of Lords.
But what I will say is that at least we had the Human Rights Act that we were able to use as a tool of defending human rights, not just in public discourse, but in the courts. And so policies like interning terror suspects without charge or trial could be challenged in court. By contrast now, with last year, the Illegal Migration Act. And by the way, this is not illegal migration. These are refugees and asylum seekers who by definition are not illegal because the Refugee Convention accepts, because of that Nazi experience, that sometimes the most genuine refugee has to escape with forged papers, hiding in the back of a boat or a lorry or whatever it is, in order to flee. So last year, the year before last, Nationality and Borders Act. Last year, Illegal Migration Act. This year, the so-called Safety of Rwanda Act. And what we see now is that the legislation disapplies the Human Rights Act from these particular people. So they become less than human. And the whole point about human rights is they belong to everybody, regardless of their nationality, their sex, their gender, their age. So you disapply the Human Rights Act from these vulnerable groups of people. And that means that domestic courts don't have, as I say, the power to properly consider their cases. And what will happen quite soon, I believe, is that refugee lawyers acting for people who came in small boats will have to make claims in the Court of Human Rights in Strasbourg because there's nowhere else to go that can properly consider their cases. And the moment they do that, Rishi Sunak will say, there you go, that's a foreign court interfering in our sovereignty. And therefore he will try and turn the general election into a referendum on pulling out of the ECHR, the Convention on Human Rights. And what he would then be advocating is that human rights would be withdrawn, not just from the desperate people in small boats, but from you, from me, from every man, woman and child in the United Kingdom. And that is the last part of the trilogy, Mr. Sunak's trilogy and his mates, which began with take back control, and then part two was get Brexit done, and now it's stop the courts, but it's really stop the boat, stop the courts, stop the law, stop all of our human rights.
For the sort of people who argue the opposite side and say, no, actually, we don't need the ECHR. In fact, we don't need the Human Rights Act. And, there's various, whether it's sort of British Bill of Rights or whatever, and their argument will roughly go, we had human rights before these things existed. They might not necessarily have been codified in law, but they existed nonetheless. Yeah. So
they're right about the values, right? That they're right that the values that are now enshrined in law in the Convention on Human Rights in the post-war period, the Human Rights Act in 1998, these values are, I think, innate. Everybody yearns for their dignity. Everybody wants to eat, but also wants to have free speech and shelter and all of these things. And they've, been a point of struggle all over the world forever. But without the law, we are all very vulnerable indeed. And until we had the Human Rights Act, for example, there was no actionable right to free speech in this country, believe it or not. There was a lot of speech and dissent, but the legal protection of your free speech was not there in British law until the Human Rights Act of 1998. So yeah, we can be complacent about these things, but if you don't have the legal protection, it means that the government of the day can just take these things away from you.
Is it not the case that there's all sorts of examples of things that weren't necessarily actually on the statute book, but as a consequence of common law and, the establishment of sort of judicial precedent that, yes, okay, it might not be in the statute book, but we've got it there in the case law, we've got it there in the common law. So
you're totally right. Look, a lot of our rights and freedoms have been protected by culture, by politics, and by the common law. But even the common law can be overridden by statute. So if you don't have something like the Human Rights Act and you don't ultimately have the backstop of, say, the Convention on Human Rights, there is nothing to stop a government with a big majority of whatever stripe tomorrow just coming along and legislating for detention without charge or trial, for the end of your free speech and your personal privacy and so on. Because the governing feature of the British unwritten constitution is what they call parliamentary sovereignty, which in practice often becomes government domination. A government with a big majority can act fairly quickly to take all your rights and freedoms away. And that is the difference between, if you like, a privilege of citizenship that can be given and taken away by the government of the day, and a fundamental human right that ought to be permanent, that ought to belong to everybody just because they're alive.
Where do you sit on a potential codified constitution then for the UK?
Well, do you know what? I've come to change my mind about it in recent years. I think for most of, I've been a law student, if you like, all my life. And for most of that time, I thought, if it ain't broke, don't fix it. The UK hasn't had a bloody civil war or a revolution for a very long time. And as you say, we've had quite a good culture of rights and freedoms and the common law and quite a strong liberal tradition, particularly in the post-war period. So if it ain't broke, don't fix it. Now I think it may be broke. In recent years in particular, when you've seen, Boris Johnson shutting down Parliament, when you've seen so many constitutional conventions ignored, the sort of good chap, what Peter Hennessy calls the good chaps theory, or what I might call a gentleman's agreement, doesn't work when all the gentlemen have left the room. So I think it might be broke now, and I think if I live long enough, I think maybe I will see in my lifetime a written constitution and an entrenched Bill of Rights. But I do think if you're going to do that, you really have to do it by consensus, and it needs to take a bit of time. It can't just be a new government, drafting a constitution on the back of a fag packet and imposing it on other parties and all the regions and nations of the UK. I think you'd have to have a sort of constitutional convention, a lot of public consultation. It should probably take at least 5 years if you want it to last 100. It's a tricky thing to do because, in the US, in France, and these other great democracies that have written constitutions, they came out of a revolutionary moment. This wouldn't be like that. And so you'd have to do it, I think, in a very careful, consultative way so that people really feel involved and they feel ownership of it.
I don't think we've necessarily handled constitutional questions that well here.
We really haven't.
It's been done
in... Also, you can't do it piecemeal. people often rightly say to me, Shami, how on earth can you justify sitting as an unelected peer in a legislative chamber? And I'm like, fair point. You can't, you would never draft a constitution this way. It is as it is because it's evolved over centuries and there hasn't been, as I say, the revolutionary moment. But what I would say is that if you're going to have a second elected chamber, then I do think you need to bolster the role of the Supreme Court. If you're going to have, all legislative power will be elected, then I think the independent referees need to have ballast as well. And so I think at that point it is really time to look at a written constitution, an entrenched Bill of Rights, and a Supreme Court that can, as a backstop, overturn human rights offending legislation as being unconstitutional.
It's actually one of the I think strongest arguments for the House of Lords, despite it being completely undemocratic, right? But nonetheless, having a broad cross-section of society, whether they are sort of, human rights experts or bishops or business people or young people, I actually quite like that. In a way, it seems bizarre because I'm generally in favour of democracy. I like the undemocratic nature of it.
Well, here's the thing, right? If you think of democracy as, a machine or a watch or a clock or something, it has to have moving parts, but it has to have fixed parts as well. And in modern democracies elsewhere, pretty much almost everywhere but Britain, the fixed point would be the judiciary. They are the referees. You talk about a lot of football on your podcast. You respect the referee. Now they're not the stars of the show, and the winners and losers and the animation of the match, that is the players, but you still have to have a referee. Now, in other constitutions, the referees are the Supreme Court, the Constitutional Court, the Conseil d'État, whatever. And we don't really have that because, as we see with the Rwanda legislation, even the Supreme Court, even on a finding of fact, is just reversed by a government with a big enough majority. Now, the House of Lords put up a bit more of a fight than the House of Commons did and demonstrated some of its strength. And some of the most powerful speeches, I have to say, against the Rwanda legislation came from Conservative peers. Some of them almost in tears when they spoke about, what's being done to our constitution and our country. But in the end, we stopped. So the Rwanda legislation as a case study demonstrated the strength and the weakness of the House of Lords, and we stopped because we lack the democratic legitimacy in the end. So I think scholars of the British Constitution will probably look at those debates in the future and say, wasn't it great? They put up a bit of a fight, but the weakness was the lack of legitimacy.
Yeah, it's kind of, you put up a bit of a fight, and then it's law. Do you know what I mean?
And then it's law. And now we have the situation that we were talking about before, which is that lawyers have been stripped of a lot of the ability to fight back for these most vulnerable people on the planet. British courts have been defenestrated by this legislation. So the place to ultimately go will be the European Court of Human Rights in Strasbourg. The moment that happens, Rishi Sunak says, foreign courts. I'm turning the general election into a referendum on foreign courts. But of course it's a swizz and it's a con, because what he will then be advocating for is that every man, woman and child in the United Kingdom, most of them citizens, will no longer have access to the Convention on Human Rights that was ironically more Churchill's legacy than it was Attlee's.
Can we talk about the language for a second? Because foreign courts won. Activist lawyers or lefty lawyers.
Guilty.
Cuff me. Is another one.
Language is so important, isn't it?
We can go further. If that's the political class, but within the media, we can go further and we can say sort of traitors, enemies of the people, etc. Those are recent examples. Could you talk a little bit about sort of how language connects to this and the way that we're characterising something that previously we would have said and described was kind of, neutral almost, politically neutral. You would say that the judiciary was separate to the political system, part of, but not in the cut and thrust of politics. And I think that's changed recently.
It's been changing in recent years. Look, we know the importance of language. George Orwell's famous essay, Politics in the English Language, I think is, in a way, even more brilliant than Animal Farm and whatever, where he analysed the way in which the abuse of language will end up with the abuse of people. And we certainly know, don't we, that framing the argument, winning the adjectives and winning the battle of words is half the way to winning the argument. But what we've seen is the demonisation of people through things like language. You rebrand people. So, for example, these people in small boats are not illegal. They're not illegal migrants. They are asylum seekers. That would be their more correct description. As it happens, most of them will turn out to be genuine refugees, which is why the government is treating them in this way. But an asylum seeker is a more neutral term to describe somebody who is fleeing a place of real turmoil and persecution and is wanting to have a claim for asylum assessed. And once you've assessed their claim, you can then decide whether they are a refugee protected by the Refugee Convention or whether they don't come within that protection and they can be sent on. But the government will not tolerate the neutral term asylum seeker, let alone the positive term refugee, and so it brands them illegal migrants.
It's to reference Orwell again in 1984, whether it's the literal destruction of language in Newspeak, so you're shrinking the vocabulary constantly, or in terms of doublethink, where you essentially wage a war on definition almost. So whether it's freedom is slavery, or we're now at war with whoever. Forget all the history.
We're permanently at war. We pick and choose.
War is peace.
Who were we at war with last week? We even forget. Lord Tugendhat, who's a Conservative peer, said of the Rwanda bill, this is from Room 101. This is O'Brien. This is 2 + 2 is 5. Conservative peer said that.
It's like, if you wage a war on words, you wage a war on the way that people are actually able to interact with reality. Because if you can't verbalise it, if you can't sort of create the structure and define the thing that you're fighting against, if you can't define reality,
you're controlling people's thoughts in a way through language, aren't you?
How do you resist if you can't define the thing that you're going to be resisting against?
Yeah, but the demonisation of the other is a big part of this far-right rhetoric in recent years.
Do you think it is far-right?
I think aspects of it are, yeah. I really do. I think the demonisation of not just people anybody you disagree with, but the demonisation of the most vulnerable people, whether they are refugees and asylum seekers, whether they are trans people, small vulnerable minorities. I think it's populist and it's far right to demonise them as a distraction from unconscionable inequality, poverty in one of the richest countries on earth. Food banks next to investment banks, and nurses that we were clapping a short while ago now going to food banks, teachers buying sandwiches for the school kids because there are so many school kids who aren't properly fed. And using the culture wars, using the demonisation of minorities as a distraction from that. I call that far right, yeah.
I think it's one of the more insidious ways that populism affects mainstream politics is that whilst, to look at the recent local elections, right, Reformgate, I think it was 2 councillors, they pushed the Tories for third place, but they're still in third place in the Blackpool South by-election. Electorally, beyond defections, so Lee Anderson moving across, they are not yet electorally a particularly powerful force, but they're sort of more nefarious and insidious impact.
Changing the conversation, pulling everybody in their direction, yeah.
Exactly.
It's a real challenge, and I just think that it is for the mainstream parties to not to ignore this trend and not to ignore the alienation and the anger from which it comes, but to address it head on. And not to get dragged further into these dark spaces, to actually have the conversation with people about who these refugees and asylum seekers are, to have the conversation with people about their housing needs, about the cost of living, rather than to fall into this trap of distraction and demonisation of tiny, vulnerable minorities.
We tried that in 2019, didn't we?
Yeah, failed. Guilty, failed. Yeah, it was. Yeah, but there are lots of things that contributed. There are lots of things that contributed to that. It was obviously it was a catastrophe. It was an electoral catastrophe, but I think which we can learn from. But we can. But learning from it doesn't mean giving up on rights, freedoms, vision. I think we can listen better. We can listen to people we disagree with, including on the right of politics. And it was, in my book, just to plug that again, I try to respect the contribution to the human rights tradition of conservatives, whether it's Churchill, whether it's Ronald Reagan, for goodness sake, who once said, "I am a refugee, I am a person in a small boat." He said that in Germany in the 1980s. Margaret Thatcher gave a speech on climate emergency in 1989 at the UN. How many of the current cabinet would ever reference that when they're talking about eco-warriors? So I do think that we should listen to other people's political traditions. I do think we should try and learn from our own mistakes. But that doesn't mean giving up on our values and getting dragged further to the right.
Let's take it back to Rwanda. You mentioned those appeals going to Strasbourg. What do you think the outcome of that will be, beyond sort of Rishi Sunak's political positioning in relation to it? I mean, in terms of the actual cases, what do you think the possible judgments and consequences and ramifications of that will be?
Well, narrowly, he has already purported to take power in the legislation to ignore interim measures of the courts. So by interim measures, I mean a bit like an interim injunction. When the court says, while we're making the final decision, you must not put this person on a plane. He's already taken the power in the legislation to ignore interim rulings of the Strasbourg court, which he calls a foreign court. And then he can do that for his machismo. And then he can sit on a different TV show and be handed £1,000 by Piers Morgan, that nice liberal progressive journalist, and the first plane can take off, even if there's just one desperate person handcuffed inside. Piers Morgan can hand him £1,000, which is probably not even coffee money to Mr. Sunak, and then he can claim that his policy is a great success, even though it's costing millions of pounds for that one plane to take off, and it's costing us far more in terms of our standing on the world stage, our commitment to rights, freedoms, and the rule of law. But then he can call that election, can't he? That can be the theatrical moment to call that election and say, "Stop the courts."
So with our legislative framework as it is now, with the Safety of Rwanda Act, I mean, is there anything there? Is it feasible to mount a legal challenge to this happening? I'm basically.
Oh, of course. I mean, of course, it's feasible to. It's always feasible to mount a legal challenge, and there are lawyers working on it right now. And we will see what creativity and what resilience our courts manage to find in the face of this legislation. But it is very difficult when Parliament makes it so, when the House of Commons makes it so clear that they are stripping courts of their jurisdiction. There are limits to what the courts will feel able to do, which is why the Court of Human Rights is such an important backstop. And even though Mr. Sunak's talking tough about all of this, let's be clear what the consequences internationally are of pulling out of the Council of Europe, pulling out of the Court of Human Rights. At the moment, there are interim measures against the Russian Federation in that court that prevent the execution of Ukrainian prisoners of war, right? And we're all for sticking up for Ukraine, rightly condemning Putin. But the key to the sort of rule of law kingdom and the human rights kingdom is non-hypocrisy or equal treatment. And if you are saying that Mr. Putin needs to obey those interim measures of the Court of Human Rights in Strasbourg, how do you maintain that position when you yourself are saying, I'm going to ignore interim measures, for example, not to send people to Rwanda? So this now becomes not just a legal consideration, but an international political consideration for Mr. Sunak, for the British Conservative Party. And by the way, there will be a battle for the soul of the British Conservative Party after the next general election, whatever happens. And I think it's in all of our interests that the more liberal, rule of law Conservatives win that battle, because it's not in anybody's interest for that to drift further and further to the right. It would be bad for all of us.
It wouldn't be necessarily anything particularly new, though, would it, for the West to be demanding an adherence to sort of an international rules-based order of other countries whilst rejecting it themselves?
You're right. It wouldn't be new. It wouldn't be new, and hypocrisy, runs throughout history. But I think the state of the world as it is now makes that kind of hypocrisy even more dangerous, because I think actually in the 21st century we're even more interconnected than we were halfway through the 20th century. And if you look at the biggest challenges that we face, that I try to address in the latter part of my book, tech and AI, war and peace, and climate emergency, you actually need internationalism and global solutions and cooperation even more now than we did in 1945. And just on this ignoring the Strasbourg court and pulling out of the ECHR thing again, what about Northern Ireland? The fragile, precious peace that was constructed, and we can do the pros and the cons of the Blair era, but the Good Friday Agreement was a massive pro. I can remember being a young lawyer in government when that groundbreaking agreement was reached. The ECHR is baked in to the Good Friday Agreement. Yep. And pulling out of the ECHR would have enormous consequences for that agreement, which is an international treaty that was supported by the USA and signed by the Republic of Ireland as well as the United Kingdom. So, Mr. Sunak can talk tough, and maybe he doesn't care because he'll be off to Silicon Valley, right? He'll be off to be head of PR for Elon Musk or whatever, but it will matter to everybody else.
It's kind of the done thing now, isn't it? Claire get Facebook.
Yeah.
Maybe she can go off and work for Elon.
What will I do?
You'll be stuck in the House of Lords, clearly. Okay. So let's say the legal challenges fail. At this point, we're exhausted. We're running out of options.
They won't fail. I mean, they'll succeed in Strasbourg. They may succeed. Somebody might, there'll be an ingenious young lawyer that may pull something out of the bag, even in the domestic courts, or there'll be an interim measure in Strasbourg. I'm not saying the legal challenges will fail. It's just that whether they succeed or fail, Mr. Sunak wants to defy them.
Yes.
And that's the point.
Absolutely.
It's not about whether the law succeeds or fails. It's about whether the Prime Minister of the United Kingdom says 2 fingers to the law. And I'm now running an election campaign, which is a referendum on the law itself.
As Lee Anderson said, right, they fucking send the planes anyway, or whatever it was, whatever he said in relation to it. Okay, so let's say we're occupying that space, right? That it's regardless of, it's fallen down in the courts, we're going to do it anyway. We've legislated, this is just happening.
Yeah. My way or the highway.
Yeah, fine. In that instance, do you think direct action is justified as a method to stop those planes going? We saw it at Stansted several years ago, right? Those guys who chained themselves around the landing gear of that plane to stop it from taking off.
Morally, could it be? Look, I've always been of the view that as a matter of conscience, direct action and even civil disobedience can sometimes be justified. Yeah, of course. Whether it happens, whether it's sufficient, is another matter. But it's always been part of protest. I think it's very important that we always retain, whatever the law is, whatever our respect for the law and the rule of law, that there is a residual space in all of us that leaves open leaves open the right to civil disobedience, particularly disobedience of unconscionable human rights violating laws, of course.
Let's move conversation on. Let's talk a little bit about Gaza. What's happening there now? So in the book, you write about the Universal Declaration of Human Rights. You mentioned it earlier, right? In response to the horrors of the Holocaust and never again, or nie wieder in German, right? Which is a sort of a phrase you'll often hear in the conversation around it. And the UN has found that there are, I'm quoting now, reasonable grounds to believe the threshold indicating Israel's commission of genocide is met and that the international community must act to prevent genocide, that the Palestinians' right to not be threatened by it is potentially in jeopardy in its provisional measures. So can you talk a little bit about how you see human rights connecting to what's happening in Gaza at the moment?
Yeah, so in chapter 6 of the book, where I'm applying human rights to war, I cite some, there's a great deal of scholarship now about the cross-fertilisation between human rights law and what we call international humanitarian law, or the law of war. And it's quite funny, a lot of people who don't like human rights law will say, but we don't need human rights law because we've got the law of war, we've got international humanitarian law. But in reality, the two intermingle. So, and that's very important, because sometimes human rights laws can give sharper teeth to the discipline of international humanitarian law. So, for example, torture is prohibited by both, but it's actually but the Torture Convention is actually a human rights it's actually a human rights law, and when we're judging what is proportionate, for example, in self-defense, and Mr. Netanyahu and his colleagues will say, well, this is a war of self-defense. It may well have been initiated as a law of self-defense, and I recognise that what happened last October was a human rights atrocity perpetrated by Hamas.
No doubt.
But when you are judging whether this is proportionate self-defense, whether the targets of your war are legitimate targets, whether the force you're using is proportionate, human rights values and laws are engaged. And, I think we've my own view is that we've well passed the point of proportionality. We passed that point some time ago. And I don't think this is a revolutionary position when even the United States, which is the staunchest, closest supporter and ally of the government of Israel, is now threatening to end arms support, has already paused a shipment of arms, I think last week, before the new movement on Rafah. Things are really, for that to have happened, things have gone really way too far. And the numbers speak for themselves. The numbers of the dead and the women and the children and the non-military targets, I think they really do speak for themselves. And I'm not alone in this. And by the way, when the protests are discussed and this terrible catastrophe is discussed, we sometimes fail to recognise there are a lot of Jewish people who feel very strongly about what Netanyahu is doing and how wrong it is. He was harming his own people and his own rule of law even before last October. Once more with attacks on the judiciary, undermining the rule of law.
Yep.
People forget in the news cycle that there were protests every weekend in Israel before October the 7th. People trying to stand up for their constitution and their rule of law. So the idea that that Israel speaks with one voice any more than the UK does. Guess what? Chakrabarti and Braverman do not agree. Guess what? And there are a lot of people within Israel itself, including family members of hostages, and a lot of Jewish people all over the world who are appalled by Mr. Netanyahu's prosecution of this war and actually the way he governs in general. Can
we talk about the arms side of things specifically?
Yeah.
Because there's been this, well, it was happened at Select Committee, and then it's kind of been rumbling in Westminster about sort of whether or not the government should publish its legal advice on the possible suspension of arms export licenses to Israel, right? And I think, well, there's a question about whether or not any government ever has, should, or would publish that kind of legal advice.
I mean, I personally, I've always been for why not be more transparent about your legal. I mean, in general, your legal advice, whether you're an individual citizen or whether you're a government, it's confidential to you, but you can waive that confidentiality if you want, and people sometimes do, to demonstrate that they have the moral high ground. Or so it's open to governments to publish their whole legal advice or a gist of their legal advice. They just tend not to, and that has been the case, I'm afraid, for governments of both stripes. But with or without the publication of the government's current legal advice, there are international jurists of great renown who have given their own legal opinion. Just a few weeks ago, there was a letter signed by, I think it's about 500 British lawyers, including former Supreme Court judges like Brenda Hale and Jonathan Sumption, and professors of law from all over the UK, publishing their view that the arms exports should be suspended at this point. And frankly, that is good enough for me. Yes, we can urge the government to be more transparent about its own legal thinking. I support that. I support that because I think we should have more transparency in government in general, let alone about things as important as this. But I'm convinced that arms should be suspended at this point. And as I said, when even the American presidency, which is always traditionally the strongest and most important ally, when even the US presidency is saying we're going to, we'll allow. I think the line at the moment from the White House is, you can have the obvious defensive weapons, but we're not going to allow you to go further in Rafah and cause even greater devastation with offensive weapons. We're going to pause that. I think when we've got to that point, the least that Britain can do is the same.
Let's talk about the one question really on the party politics of it, specifically the Labour Party politics on it, because what you've just said there, Sadiq Khan has said similar, right, about ending the export licences.
Yeah.
And that's a departure actually from the central Labour Party position on that Keir Starmer hasn't come out and said that yet. And actually, his position on this has evolved over time. I think I saw the FT described it as something like the evolution of his policy, which I thought was quite a clever way of wording it.
Yeah.
But, in the initial immediate aftermath of the attack, right, and just to be clear, we're talking about Keir Starmer, former human rights lawyer, and also Emily Thornberry, who herself, again, very accomplished lawyer. And Starmer gets asked on LBC by Ferrari, does Israel have the right to cut off food and water to Gaza? And he says, I do believe, I think he actually sort of says she rather than it, but she has that right to do that. And there still are people, even though the Labour Party's position on that has now changed, who look back on that moment and say, you used to be a human rights lawyer, you must know that.
Well, that was, look, after some time, and that was a problem, wasn't it? There was some doubling down and then there was a correction.
Yeah.
But I believe, you can tell me that if I'm wrong, I believe that what was said was he was answering a previous question, or right. So the line from the leadership is that was a mistake under pressure from Nick Ferrari live on air. And I think people are allowed to make mistakes. I think it's good to correct the mistake as swiftly as possible when it's a mistake of that magnitude, because plainly you don't have the right in international law to cut off food, water and medicines from 2 million people in response to even the human rights atrocity of October the 7th. But I think the correction was made. Politically, it's very unfortunate perhaps that it took as long as it did, but it was in error. And that error is now accepted, but it's upset a lot of people, and not just British Muslims, by the way.
Yeah.
I know lots of people who are not Muslim who were very upset by that because of their belief in human rights and because of their belief in international humanitarian law and humanity and so on. So yes, you can turn it into a sort of electoral game about, you know, which constituencies have Muslim votes and so on, but it's more than it's much more than that. It's people of all faith and none who were upset by that, and that just needs to be corrected as often as possible. I think the nature of our unforgiving politics is sometimes that it's harder to apologise, it's harder to correct. The instinct is to double down, and I think some of the people that are, some of the political advisor class, whoever's the leader of the party, by the way, are a bit macho about doubling down rather than reflecting. But yeah, what can I say? That was a mistake, and it needs to be acknowledged, and maybe it needs to be acknowledged many times over. But there should be no problem with saying I made a mistake, I got that wrong, we got that wrong, and no, of course, self-defence is a very important principle in international law. Of course, it is, but it is not unfettered. It's not unfettered in domestic law, right? If somebody breaks into my home, I am allowed to defend myself, you know, grab the kitchen knife and whatever. But if I chase the person out of my home, into the street, into the next street, into my neighbour's home, and start, you know, killing their children, that is not self-defence.
No, it's not. Yes, to be clear, so that interview moment, his previous answer, he says, Israel has the right to self-defence. Ferrari says, does it have the right to cut off food and water? And he says, she has that right. And I think what he has since said is that when he was saying she has that right, he's saying she has the right to self-defence.
Yeah, but those of us that, it is possible to make mistakes under pressure.
Of course it is.
Under pressure on a very difficult topic on national radio. Let's be honest about mistakes. Let's try and correct them as quickly as possible, and let's not have our army of bright young men in suits doubling down. You know, maybe that's something we should all reflect upon. That was a mistake. I'm glad it's been accepted, but of course, with the nature of social media as well, the mistake will be clipped and repeated and repeated and repeated.
Without the bit that came before.
Without the bit that came before, and perhaps the correction needs to be repeated too. This is the nature of campaigning and communications in the 21st century. It is not easy.
That's a really interesting point about communications in the 21st century, because I think something about this conflict that's had quite actually disassociative effect and really powerful consequence in terms of sort of our right for protest is that you've had the kind of national discourse in media and politics combined with the quite revolutionary power of social media, where you're just seeing the destruction. You're seeing the people being pulled out of the rubble. You're seeing the brutality of what a war looks like, in the same way we saw it with Ukraine. And I would actually draw a parallel perhaps to kind of, you know, the TV crews that were out there during the Vietnam War that then sort of were the catalyst for this ginormous mass protest campaign that happened as a result. And here in the UK, we're seeing a rejuvenation of mass protests, you know, endless marches right in London against the war. Admittedly, I think the student campus sort of sit-ins and campings here don't quite have the same kind of, I don't know, they're not as militant as what's happening in the States. There's no tear gas, there's no mace, and there's no fighting yet.
Thank goodness.
Yeah, it's quite tame. But nonetheless, in light of the legislation that's happened in relation to protest, in relation to free speech and freedom of association, we're kind of seeing that actually there is still, it hasn't had much of an impact on cracking down on mass protest here in the UK. Well,
and I'm glad about that. And I'm proud of the young people in particular. They're not all young, but I'm proud of the people who are standing up in that way, even at the risk of arrest and imprisonment and so on, because the legislation is theoretically much more draconian than it was. But I also think, and you may be surprised to hear me say this, that the police under the new Met Commissioner have been doing pretty well as well in very difficult circumstances, under political pressure from Mr. Sunak and his cronies, lecturing the police, almost ordering the police to go and arrest more people. They have held the ring and sometimes had to navigate protests and counter protests, and they've kept the peace. They've kept the peace, and they've done it, really rather well, perhaps even compared to some of their US counterparts. So that is something to take some hope and optimism from, I think.
Yeah, and having to balance the sort of, that new legislation alongside the right to free speech, right? And essentially,
the thing about policing protest, as opposed to other forms of policing, is it isn't principally about enforcement. If you're talking about the law of theft or the law of rape or violence, you really do, in order to maintain the rule of law and respect for the law, you really do need to be conducting investigations, arrests, prosecutions. Otherwise, you decriminalise the law of rape or the law of theft or whatever it is. When you're talking about policing public order, you're really keeping the peace. And the primary responsibility is not actually to enforce every letter of the law that says noisy protest is now a criminal offence. The crucial thing is keeping people safe and not becoming a public order problem yourself because of your heavy-handed policing, protecting different groups of protesters from each other, keeping people safe just because having big crowds can be dangerous even if they're all on the same side.
Yeah.
It's a different challenge. And I think so far, week after week, touch wood, under the new commissioner, the police haven't done too bad a job.
Final question. We've been speaking about human rights, refugees, and I think one of the sort of a moment that a lot of British people feel quite proud of is in the wake of Russia's illegal invasion of Ukraine, there's homes for Ukraine, right? We see record immigration into the UK, a significant part of which is the fact that we've welcomed with pretty open arms Ukrainians into our society.
And the public is supportive of it.
Yes.
And they will take them into their homes, and that's a wonderful thing. And it shows the potential. It shows the potential if we don't demonise the refugee, but we understand and we sympathise and we stand with them. Look at the capacity that people have for solidarity with other human beings. And we should take heart from that, and we should learn from that, and we should practice that in relation to people from other places too.
So that would exactly be my question, is do you think we will, and if not, why? There won't be something reciprocal or similar for what's happening in Palestine right now?
Well, I hope there will be. I hope there will be. And I see the capacity for that everywhere, especially amongst my Jewish friends. And I read the Israeli press and see, as I say, some of the criticisms of the way, Mr. Netanyahu does not represent all of those people and their interests any more than Mr. Trump represents every American. Let's understand the diversity of thought in other people's countries as well as our own.
Shami Chakrabarti, it's been really interesting talking to you. Thank you for coming in. Appreciate it.
Cheers.